बाद मुनाकिदा कौमी सेमिनार से खिताब करते हुए कौमी इंसानी हकूक़ कमीशन के चेयरमैन जस्टिस वी रामा सुब्रमण्यम ने कहा कि इजहार ख्याल की आज़ादी का मतलब दूसरों के जज्बात को ठेस पहुँचाना नहीं है। उन्होंने कहा कि हिंदुस्तान एक कसीर मजहबी, लिसानी और सकाफ़ती मुल्क है जहाँ एक ही उसूल सब पर लागू नहीं हो सकता। इसके बावजूद जो अदलिया ने हर फ़र्द को इंसाफ फराहम करने की भरपूर कोशिश की है। सेमिनार में तेलंगाना ह्यूमन राइट्स कमीशन के चेयरमैन जस्टिस डॉक्टर शमीम अख्तर और दीगर माहिरीन क़ानून ने शिरकत की। मुक़र्रिरीन अदलिया को इंसानी हकूक़ के महाफ़िज़ करार दिया और अदालती निज़ाम में इस्लाहात की ज़रूरत पर जोर दिया। मुंतज़िम सैयद अली ताहिर आबिदी ने बताया कि इंसानी हकूक़ की पामाली पर शऊर उजागर करने की गर्ज से ये सेमिनार मुनक़िद किया गया।
The facilitation for access to justice is the first area that the court have done remarkable work. And all this legal service, in fact, Legal Services Authorities Act came in 1987. But much before that, access to justice was ensured even by treating a letter written to the Chief Justice of India as a writ petition. So the first area where the courts made remarkable contribution towards improvement of the human rights of citizens is improving access to justice. All of you know that Article 226 of the Constitution enables the citizens to approach the high courts with writ petitions. Article 32 empowers citizens to approach the Supreme Court with writ petition. The crucial distinction between Article 32 and Article 226 is that Article 32 by itself is a fundamental right. Therefore, the courts increased access for the common man to justice. This is the first area. You must remember, India is not a very easy country to govern. It is not a homogeneous country like any other developed country. Today, if you take statistics, the population of India has crossed about 1.4 billion, which is nearly 1/6 of the entire population of the world. This 1/6 of the population of the world is living in a land mass which is equivalent only to 2.4% of the total Earth's surface.
Visaka guidelines. When there was no statutory law to address sexual harassment at workplace, these guidelines were derived from international human rights treaties and laid foundation for enactment of a legislation called the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. In People's Union for Civil Liberties versus Union of India, the Honorable Supreme Court recognized the right to food as a part of the right to life under Article 21 of the Constitution and passed several interim orders directing proper implementation of food schemes namely Midday Meal Scheme, Antyodaya Anna Yojana and Public Distribution System. In Olga, Tellis and others versus Bombay Municipal Corporation and others, the Honorable Supreme Court recognized that the right to livelihood is an integral part of the right to life under Article 21 of the Constitution. It provided judicial recognition to the plight of pavement dwellers, asserting that their eviction without rehabilitation violates constitutional rights. In a historic case in Justice K.S. Puttaswamy and another versus Union of India and others, a 9 judges bench decision of the Honorable Supreme Court declared that the right to privacy is a fundamental right under Article 21 of the Constitution. The historic decision has far-reaching implications on laws relating to surveillance, data protection, and personal autonomy. In Prem Shankar versus Delhi administration, rights against handcuffing was discussed as handcuffs violate one's human right. The right to know is a fundamental component of Article 21 of the Constitution and was upheld by the Honorable Supreme Court in Goodall versus State of Bihar. The Honorable Apex Court acknowledged that participation in democracy requires this right. The Honorable Supreme Court in Paramananda Katara versus Union of India held that an employee's right to health and medical assistance is covered under Article 21 of the Constitution.